So my name is Dr. Anna van Riebe, and I am the founder of Ocean Vision Legal. Ocean Vision Legal is the first international law firm worldwide that entirely specializes on marine protection. And for me, for this reason, obviously, today it's a special honor to talk after ITLA's president, Haida. And while we now have taken a very close look on one particular legal action, the COSIS advisory opinion, I want to zoom out again with you and explore the topic of ocean law or law of the sea from a broader perspective, especially from a lawyer's perspective. So many of the more general points from President Haida on UNCLOS this morning, you've already heard about and you will hear again, but just consider it as a good learning and so that it can really sink in. Okay, so let's get started. When we talk about ocean law, this is a very broad topic. So firstly, what I ask myself, what does it really mean? And when I think of ocean law, there are two branches. There is maritime law on the one hand, and the law of the sea on the other hand. Maritime law is a sector of private law or international private law, and it mainly governs the commercial relationships arising from shipping, such as contracts for carriage, charter parties, insurances, even collisions and salvage. So it really mainly regulates the rights and liabilities of the private actors, such as ship owners, charterers, cargo interests, or insurers. As you can imagine, this is actually a sector in which quite a bit of monetary interest is involved. As for example, insurances of such big cargo ships are really high. So this whole brand is really covered well by bigger law firms, mainly in the port cities such as Hamburg. On the other hand, we have the law of the sea. The law of the sea is a branch of public or public international law. As public international law governs the relationship between and amongst states, the law of the sea also governs the rights and the duties of states over different topics, such as maritime zones, navigations, resources, or the protection of the marine environment. So in short, while maritime law is part of the private law sector and concerns ships, law of the sea is part of public or public international law and concerns states. So when we talk of ocean law today, I therefore refer to the latter branch, which is law of the sea. Okay, let's dive deeper into this. The law of the sea is actually one of the oldest fields in international law. It can easily be traced back even to the age of discovery in the 15th century, when especially European colonial powers sought to expand maritime trade and wanted to secure exclusive access to lucrative sea routes. And it can so easily be traced because there is actually writing. Since after Columbus's voyage across the ocean in 1492, Pope Alexander actually issued a papal bull which divided those newly discovered territories and their surrounding waters between the sovereignty of Spain and Portugal. And in the following year, this division was formalized through the Treaty of Tordesillas. So this formalization actually allows us to trace back the origins in the law of the sea, and it also introduced the idea that parts of the ocean could actually be subject to exclusive control. And in the next decades and centuries, there were fierce intellectual battles over whether the ocean in general should be open to all states, or whether it should be closed and be separated among the leading colonial seafaring powers, such as Netherlands, Portugal, and England. This kind of battle continued and was then settled in 1609 by the Dutch Hugo Grotius, who wrote a dissertation called Mare Liberum. And as the title already suggests, he championed the principle that the high seas in general should be free. This was strategically advantageous for European colonial nations because they wanted to keep the open ocean to commerce and navigation, as they needed this for free trade and access to raw materials. So Grotius' doctrine of the freedom of the high seas then actually developed into one of the longest standing principles of international law, still applying today. What this also shows, and what is an important point, and I will get back to this later, is that the law of the sea evolved based on the needs of that time, of that era. So it began with a spatial distribution of ocean zones because this was what was the issue at hand, and it clarified whether the ocean is free or not. Conflicting to these freedoms of the high seas, also, the states obviously had an interest in securing resources, such as through fisheries, and wanted to have sovereign rights. This particularly around their coastal waters and where they did want to assert these sovereign rights. So historically, and still today, one of the most enduring tensions in the law of the sea is this conflict between the principle of mare liberum on the one hand, which is the freedom of the high seas, and mare clausum, the closed sea, in which the states can assert sovereign control, at least over parts of it. And today, following this, the ocean is divided into 5 zones. And this is a repetition of what we heard this morning, so this can really just clarify and sink further in. So the water column is divided into 3 zones. It starts with the high seas, which still is free. The opposite of the freedom of the high seas is the territorial sea. The territorial sea is a belt of water adjacent to the coast in which the coastal state has full sovereignty. So it's like land. So it's where really it belongs to the territorial sovereignty of the state. It extends 12 nautical miles from the baseline on the coast, which is a line along the coast from which maritime zones are measured. And in between the territorial sea and the high seas, there is this special zone called exclusive economic zones. And as the title already suggests, it is really dedicated or was invented to appease economic interests of the states, who, beyond these 12 nautical sea miles, still wanted to have access to resources that lie beyond. The exclusive economic zone does not exist ipso jure, but has to be designated. So it has to be established by the coastal state. It does not exist per se. It can measure up to 200 nautical miles of the baseline on the coast, but not every state has it because it has to be designated. For example, the Mediterranean Sea would actually be entirely the exclusive economic zone of the coastal states, but the states did not designate it, so therefore it is the high seas. And indeed, the delimitation of sea borders between states with opposite or adjacent coasts is a very complex process and would also be very complex in the Mediterranean, where it is this basin where these borders would really overlap. UNCLOS also foresaw that and has a whole part on the delimitation of sea borders. And where a conflict arises, states may bring disputes over such maritime boundaries to the International Tribunal for the Law of the Sea that helps to pacify them and to solve them. And another famous example of this of the delimitation of the sea borders is actually Germany. Because when we look at the German coast, and when this would actually lead to a situation, because it is shaped in this kind of angle, that if the sea borders would close so that there would not be any access for Germany to the high seas. So therefore, this, by the way, is called the duck's beak, the so-called Entenschnabel, which is an adjustment of the sea borders, so that allow that Germany still has an access. So this is so UNCLOS allows for an equitable delimitation of sea borders, so that they can be adjusted to ensure that the coastal states maintain fair and practical access to the sea. But as you can see, this can be a complicated process. And turning back to the maritime zones, we still have two zones left, which are on the sea floor. There is the continental shelf, or in German, the Festlandsockel, which is either as broad as the outer edge of the continental shelf, or if it's de facto shorter, it can be designated up to 200 nautical miles. Anything beyond that, the sea floor under the high seas, is called the area, and it is the common heritage of humankind. So summarizingly, we have three zones in the sea, the territorial sea and the exclusive economic zone, in which the states have sovereignty or sovereign rights, and these areas are therefore called areas under national jurisdiction. Everything beyond that, where the high seas start and where the freedoms of the high seas govern, and where the states do not have sovereign rights, is called areas beyond national jurisdiction. Okay, so how did this come into being? How was this regulated? We've also heard a little bit of UNCLOS, so this is a quick repetition. So up until the mid-20th century, principles in the law of the sea were mainly governed by customary law. And efforts to establish a stable, comprehensive legal framework inter alia to really sort out these maritime zones led to three successive United Nations conferences on the law of the sea, starting in 1958. And after almost 10 years of negotiations, at the third Law of the Sea conferences, the United Nations Convention for the Law of the Sea was adopted in 1982. UNCLOS, as we call it, is also called the Constitution for the Ocean. And on the day of its opening, UNCLOS was signed by an unprecedented number of 119 states. As President Haida already elaborated on, it was UNCLOS has this package deal, and it took a long time to negotiate it to get everyone to consent to it. So there then was also a great number of states that actually signed UNCLOS on its opening day. UNCLOS is a comprehensive framework that regulates different topics. It regulates the sea zones, the maritime zones, navigation, marine protection obligations, and much more. UNCLOS is not only called the Constitution for the ocean, but it is also called a living instrument. Why? Because like a constitution, UNCLOS provides abstract and general laws that can survive over a long period of time. And this is evident by actually two things. One, it has very visionary articles. For example, Part 11 UNCLOS focuses on the exploitation of minerals in areas beyond national jurisdiction, which we called deep sea mining. Deep sea mining is a planned activity in those areas beyond national jurisdiction, and it aims to mine minerals from the seafloor in depths up to 4,000, 6,000, 7,000 meters. The problem is that the effects on the marine environment are not yet fully understood. And the process is also technically very complicated and expensive, so it still hasn't started today. We are closer to starting it more than ever, with great concern from the scientific community on the effects of the marine environment. But what is truly remarkable and what I want to refer to here is that UNCLOS was adopted in 1982, and in 2025, this is a technique that we can still not pursue because it's so difficult. And yet, UNCLOS foresaw this and has these regulations. So UNCLOS has quite visionary articles, which make it still applicable. But even more than that, why UNCLOS is a living instrument and can survive over such a long time, like the Constitution for the Ocean, is because of the open way that the articles are framed so that they can actually be interpreted by ITLOS and judicial bodies. So this is one of the really important points of it, that, for example, the COSIS advisory opinion that President Haida introduced before, it applies to the obligations of states to protect and preserve the marine environment, which is regulated in Part 12 UNCLOS. And because it is formulated so open, we can even apply contemporary issues such as climate change, which were not issues that were so pressing back when UNCLOS was adopted. So, because the provisions are abstract in general, judicial bodies can interpret them and keep UNCLOS alive over a long period of time, which is why we call it a living instrument. Other contemporary issues that arose during the time in which UNCLOS was negotiated was actually the harm to the marine environment by human activities in the sea. In the mid-19th century, incidents occurred that revealed the ocean's limits. On this picture, for example, you can see the Torrey Canyon oil tanker accident, which showed the devastating effects of oil spills and made visible the adverse effects of human activities on the ocean. So new needs beyond just the delimitation of sea borders arose, especially including the need for marine protection. And UNCLOS, beyond regulating traditional concerns, such as the maritime delimitation and the zones of the sea, also contains provisions on resource exploitations or marine protection. The protection of the marine environment, as we heard, is regulated in Part 12 UNCLOS. And together with the latest jurisprudence, such as the COSIS advisory opinion, we can actually now see a general development in international law from the sovereignty of states to stewardship. Because the COSIS advisory opinion is not the only advisory opinion that was issued in the last year or 1.5 years. Actually, there have been 3 simultaneous advisory opinions from International Court, with COSIS being the first, and also direction giving advisory opinion to which other courts applied, but also the International Court of Justice and the Inter-American Court of Human Rights delivered advisory opinions on climate change that referred to the ocean and the marine environment. Another really important development is the development of the human right to a healthy environment, which is an emerging new human right that is already globally recognized by the United Nations and regional courts such as the Inter-American Court of Human Rights or the European Court of Human Rights. Beyond this jurisprudence and development of single rights, there are also new international treaties. One that we're going to look at in a second, called the BB&J Agreement, that was adopted in 2023 and acknowledges the need to sustainably regulate biodiversity beyond national jurisdiction. So when we talk about ocean law or the law of the sea, this can concern traditional conflicts, such as the sovereignty over marine areas, but also contemporary needs such as deep sea mining, marine protection in the light of climate change, or resource exploitation. And to this end, we want to take a little bit of a closer look at this BB&J agreement. So the Biodiversity Beyond National Jurisdiction Agreement, and we have already learned that beyond national jurisdiction means the high seas and the areas, was adopted in, firstly, represents one of the most significant developments in ocean law since UNCLOS itself. It was adopted in 2023 after nearly 20 years of negotiation. And it is designed to fill UNCLOS and to implement UNCLOS, therefore it's an implementation agreement, with regards to Part 12 UNCLOS, the obligation of states to protect and preserve biodiversity, and here particularly in areas beyond national jurisdiction. I want to bring your attention to these areas of national jurisdiction and why it is so important. Areas beyond national jurisdiction, which is the high seas, cover roughly 2/3 of the ocean. So this is why we actually talk about it so much, because it's the vast majority of the ocean lies beyond national jurisdiction. And this September 2025, a paramount step has happened with the 60th state ratifying the BB&J agreement, which triggered its entry into force on 17th January 2026. So the BB&J will enter into force in January 2026. The BB&J has 4 main sections and creates a legally binding framework for sharing benefits from marine genetic resources. It has provisions on the designation of marine protected areas on the high seas, on conducting environmental impact assessment, and it aims to strengthen international cooperation and capacity building. So also here, we see a very important shift from sovereignty and exploitation to stewardship of the ocean. And BB&J operationalizes many principles of the UNCLOS, especially Part 12, and gives it contemporary meaning. Once in force, it will be the 4th implementing agreement under UNCLOS, alongside those on deep sea mining, fish stocks, and the ITLOS statute. So in many ways, the BBNJ agreement is the contemporary implementation of UNCLOS in the 21st century, and it brings to life the legal structure of the idea of a shared ocean commons. So why is this so important? Because the ocean is still in a dire state. Although 195 states have committed to designate 30% of the ocean as marine protected areas by 2030, which we call the 30 by 30 goal, and which is the scientifically recommended minimum to maintain ocean health, today, only 9.61% of the entire ocean and a meager 2.8% of the high seas are protected. Today is 2025. This goal was set in 2020. So this is far away from achieving the 30 by 30 goal, halfway through the aim. And this, although the high seas make up 2/3 of the entire ocean, even more than 70% of the Earth's surface is covered by the ocean. So this shows why protecting it is so important. The ocean, as ITLOS established also and confirmed in its advisory opinion, is the largest carbon sink on Earth. It absorbs about 25 to 30% of global CO2 emissions, and it captures more than 90% of the excess heat generated by human-induced climate change. So the ocean produces, additionally, it produces over half of the oxygen we breathe. It is home to 80% of all life on Earth. So the ocean regulates the global climate, it drives weather systems, and it sustains the food, livelihoods, and cultures of billions of people. In short, the ocean is vital to sustain all life on Earth. And without the ocean, we would quite literally run out of air to breathe. Yet, only a shocking number of 2.4% of the ocean has been assessed and deemed effectively protected. What does that mean? So most marine protected areas, which are areas in the ocean that are closed for human activities or in which human activities are regulated, but only 2.4% of them are actually regulated in a way that these restrictions are enforced and managed. So while there are 9.6% of the ocean designated as marine protected areas, this only exists on paper. Only 2.4% are actually enforced so that there are laws in place and monitoring programs and management systems to ensure that the protection regulations are being upheld. And this gap or this problem is exactly where our work as lawyers can begin in ocean protection. So ocean protection is one of the contemporary issues in the law of the sea. And it is also what we are focusing on in my firm at Ocean Vision Legal. How did this come into being? So over the last years, we saw a surge of a specific litigation type, which is climate litigation. And when I founded my firm in 2023, I was wondering, why do we not have that for the ocean yet? Why do we not yet have ocean litigation? Threats to the ocean are becoming more severe. At the same time, our understanding of how human life and health depend on the ocean is also growing. So, when we want to apply the law of the sea in a contemporary way, there needs to be a shift from viewing the ocean only as a resource to recognizing its ecological integrity and its intrinsic values. And to this end, in my firm, we are working on two angles that I quickly want to introduce. The one is that we are working on judicially enforcing the existing marine protection obligations, which is called ocean litigation. The other branch is called ocean rights, where we work on developing new laws that recognize the intrinsic value of the ocean with inherent rights. That sounds a little bit abstract, so I'm going to explain just a little bit more on this. So, although UNCLOS is groundbreaking, much of its language still treats the ocean as a resource. For example, fish is referred to as fish stock. Stock is something that is on the shelf in the supermarket that you buy. So by its very name, also the United Nations Fish Stock Agreement regards fish as a resource instead of saying, for example, populations. And we are working on developing new laws that reflect that the ocean and nature has intrinsic values and inherent rights. This means that we recognize that the ocean has its own rights and it does not only need to be protected because it provides resources for humans, but simply because it is the ocean. So we don't only need to protect fish because they are a resource for humans, but realize and recognize that fish also have intrinsic values and that must be recognized. And this whole new legal stream, which is emerging worldwide, is called rights of nature. And when we apply it to the ocean, it's called ocean rights. From a lawyer's perspective, we advise states on how to implement these frameworks into their national jurisdictions. For example, we worked recently with a group of indigenous peoples from the Pacific to establish a whale personhood sanctuary. This is a zone in the sea where the legal rights of whales are recognized. And this was adopted by the leaders of the islands, the traditional leaders, the indigenous leaders of the islands. And now we work together with the governments to incorporate this into their national laws. But there is also, as I said, a global recognition of rights of nature or ocean rights. Ecuador, for example, recognizes rights of nature in their constitution. And also the Inter-American Court of Human Rights has a number of jurisdictions in which it already recognizes the rights of nature because of the Ecuadorian constitution, but also because they say rights of nature is actually a special interpretation of the newly developing human right to a healthy environment. So when we build on this, there's actually a global legal foundation to recognize rights of nature already. New Zealand, for example, recognized the rights of rivers already. In Germany, we do not yet have a special rights of nature law or legal foundation. However, Spain, for example, has recognized the rights of the Mar Menor lagoon, which is a lagoon in the Mediterranean, and provided it and granted or accepted the legal personhood. And while we don't have a legislation in Germany yet, the Regional Court of Erfurt actually, in one of the diesel procedures, mentioned the rights of nature, indicating a trend towards recognizing nature's own rights. What we are working on at Ocean Vision Legal is even a universal declaration of ocean rights for the universal acceptance that the ocean has intrinsic values and to initiate a paradigm shift in how humans relate and interact with the ocean. So, summarizingly, while UNCLOS and these marine protection frameworks are quite groundbreaking, we still need new laws that also recognize the intrinsic value. At the same time, and very interestingly, we also have a branch where we need to enforce the existing obligations that already exist, such as Part 12. In this UNCLOS, in this branch, we call ocean litigation. In ocean litigation, when we look at this, there is obviously the International Tribunal for the Law of the Sea, which is the specialized court for law of the sea matters and was established in 1982, inaugurated in 1996. It currently has 169 state parties and the EU. And as Judge Haider already mentioned, President Haider, there are different kinds of procedures. If we keep them very broadly, there are contentious cases for disputes between parties, and there are advisory opinions, as we heard, the COSA's advisory opinion, which are interpretations of the law by the tribunal. The practical limitations from a lawyer's perspective are particularly, as we already said, law of the sea is a branch of public international law, so proceedings can only be brought by states, and it's quite difficult or takes some time to get state support to actually bring a proceeding. And also one of the most severe limitations is that obviously only the state parties can be bound. And parties who are not, or states who are not party to UNCLOS cannot be bound under these provisions, except where they are customary international law, such as the obligation to protect and preserve the marine environment. Beyond actions in international law, ocean law also exists in the EU and Germany. So in EU law, there's actually an upswing in ocean litigation. There are legal actions that have been filed to limit bottom trawling, which is a very harmful fishing techniques, in the marine protected areas in Europe, all in various countries, including France, Spain, Netherlands, Italy, Sweden. Also in Germany, where Ocean Vision Legal represents BUND für Umwelt und Naturschutz, in a proceeding against the Bundesanstalt für Landwirtschaft und Ernährung for allowing bottom trawling in European MPAs. So this is a lawsuit. This is currently going on. Simultaneously, there have been even complaints to the EU Commission to initiate infringement procedures against states who do not enforce those legislations, those secondary EU law that requires them to effectively manage the marine protected areas. So there are different legal actions going on. And also politically, there is a lot happening with the EU looking at strengthen marine protection. It has just adopted the EU Ocean Pact with the goal to close all marine protected areas for bottom trawling by 2030. So for lawyers, there's actually quite a bit of work or cases that could be pursued in this regard. Sorry. There is a growing intersection between international obligations and business law. So we could think about marine pollution liability, the regulation of fisheries, ESG reporting on ocean impacts, or in Ocean Vision Legal, for example, we are working even on implementing ocean rights into the ESG evaluations. So there is a high economic cost also for non-compliance, which could be a leverage point for lawyers to look at when we think of shipping, fisheries, energy, or the finance sector. and which are increasingly exposed to legal, reputational, and litigation risks. So where are we going from here? There already is a precedent, and we heard it before. It's climate litigation. When we think of climate litigation, only a few years ago, it wasn't a term in itself. There might have been single climate litigation cases, but this whole wind of climate litigation just rose recently, and now everybody knows what we're talking about when we're talking about climate litigation cases. It is like this fresh wind that was going around the world and motivating people of all ages, young people suing the government, old people suing the government, and taking them to court for failing to reduce greenhouse gas emissions. So, like the wind of climate litigation, it is our ambition to create a wave of ocean litigation to strengthen the marine protection laws and legally enforce ocean protection obligations. And in my opinion, I think this is what ocean law is developing into today. Thank you so much for your attention. Please don't hesitate to reach out should you have any questions. And I hope that you enjoy the rest of your day. Thank you very much.